Hello, everyone, and welcome to this extended edition of John Redmann, Power of Attorney. I'm Shauna Sanford, along with attorney John Redmann, and we have as our guest here attorney Seth Nehrbass to continue our conversation on intellectual property. So much information, and so we wanted to continue this conversation. But one of the things that we really want to get into is what sort of legwork can we do beforehand, before we get to that patent? What sort of research can we do?
I'm glad you asked. There's an excellent website called freepatentsonline.com, which allows you to do searching of U.S. patents, published U.S. applications, international patent applications, European patent applications, and journal articles, all at one site. It's very easy to use, freepatentsonline.com. I recommend that for patent searching. If you have an invention, go there. If you have a trademark, I suggest that you first look at Google and see if you can find someone else using your proposed trademark in the same way that you intend to use it, and then go to uspto.gov. That's United States Patent and Trademark Office.gov, and you can do trademark searching there at the register to see what's been registered with the government.
And so, you know, this is a free search engine site.
Right.
In other words, it's not going to cost you anything.
Right.
And if you don't find anybody with that same patent, then you know you're off to a good start.
Yeah.
Right. And in the old days, we used to do searches in Washington manually through the records of the Patent and Trademark Office. And about half of the inventions would get knocked out at the search stage. Often my clients can do searches on their own and find out that they're dead in the water on one of their inventions, and then they can focus on a different one.
Very important, because it is an investment in order to get a patent, right?
It
is a
indeed.
huge investment.
It is.
What are some common mistakes that you see out there?
Oh gosh, there's so many. But
that we can help people avoid.
But when it comes to patents, people try to hold the most important part of the invention out of the patent application. So they don't really tell the patent office how to make and use the invention, and therefore the patent's invalid because the inventor hasn't satisfied his share of the contract, which is to disclose how to make and use the invention.
And maybe because they're wanting to keep it close to the vest, it's a secret. We talked a little bit earlier about trade secrets, but that may not necessarily fall into that category, right?
You have to choose between getting a patent and keeping something a trade secret. You can't have it both ways. You can't try to patent part of the invention and keep the rest of it a trade secret.
Hence the value in having a good patent attorney to guide you through those waters, because you could spend a lot of money, waste a lot of time, or you could spend a lot of money, get it done right, and then hopefully have a product that's going to bear a lot of fruit for you later on.
Right, exactly, yeah. Other common mistakes that you see?
In patents, people wait too long to file a patent application. That's huge. As we talked about before, you have a year from the time the invention is first used in the United States in public, put on sale in the United States, or is described anywhere in the world in a printed publication of some type. If you don't file within that year, in general, you can't get a valid U.S. patent.
Okay, so very, very important. This whole issue of fair use, what is fair use? Explain that. Okay,
fair use of a copyrighted work is one where you may quote from a book when you're commenting on it. John Redmann writes a new book. The television station reads it and they say, you know, we read John's books, it's great, we love it. In fact, here's a clip that we found especially moving. That's fair use. That's an example of fair use.
So is it difficult to prove that maybe somebody has ripped something off from someone then? How hard is that?
It depends. You know, often you'll see an allegation of ripping off in songs. Someone will come out with a song that an earlier artist will say, wait a minute, My Sweet Lord sounds a whole lot like this song that
we've heard that lots of times, right?
Exactly.
Right.
And it may be an unconscious effect by the later artist where he didn't realize that he had that other song in his head, and he came up with My Sweet Lord, which sounds a whole lot like the earlier song. And I think in that case, the court found that it was copyright infringement.
Really? Very, very interesting. We've heard a lot of those kinds of cases. So I've got a question for you about royalties then when it comes to writing songs, performing songs. Who gets the royalties? Is it the songwriter? Is it the band? Who is it?
It depends, again. But in general, if the songwriter records his copyright and keeps it in his own name, then when someone else performs, they're supposed to pay a royalty back to the copyright owner, who in this case would be the original songwriter. But often what happens is all of these rights are given to a publishing house. And the publishing house then registers these rights with BMI or ASCAP, who then chases down uses of the of the songs and gets money from people who use the songs.
I see. So very, very important there to know to copyright these songs.
Right.
Yeah.
And it's also important if you're a bar owner and you're playing music, live music, or you're playing recorded music, to have a license from ASCAP or BMI. It's usually relatively inexpensive, and it's a lot cheaper than the damages that these bar owners would have to pay in court if they get sued by ASCAP or BMI.
And I was going to follow up with that. If you don't pay the fines or the penalties, excuse me, if you don't pay the royalties, what sort of fines or penalties are you looking at if you get caught?
Okay, in general, maybe the license fee might be $1,000 a year. In general, the damages will be likely in the hundreds of thousands of dollars, if not millions of dollars.
Wow.
That's tough.
It's very costly.
Right.
Very costly.
How often are bar owners, let's say if you have a jukebox or you have a live band playing music in your house, in your bar, how often are they brought to account?
Well, usually BMI or ASCAP will write a letter, polite letter saying, you know, we understand you're playing live music or recorded music that our artists own, and you need to, you know, give us $1,000 a year and we'll let you continue to do it. Most bar owners have the good sense to accept that offer.
It's $1,000 for all the songs?
Don't quote me on exactly how much, but in general, I think it's about $1,000 a year, as opposed to tens, hundreds, or even millions.
Just do the right thing, right?
Right,
Just
exactly.
do the right thing. We are quickly running out of time here, so before we go, just any last-minute tips that you'd like to give our viewers out there as they consider, you know, filing for a patent or a copyright or a trademark?
Well, again, I would encourage them, if they have an invention, to seek assistance from a patent attorney as soon as possible. They can try to register copyright on their own. Trademarks, they ought to do some searching, and I still recommend that they use an attorney if possible.
And one last thing, though. Go to the website, johnredmannpoa.com. There's forms, information that'll flesh out a lot of what we've said here on this clip and these clips. And we'll provide the two. You can download it and visit these websites we've told you about.
All right. A lot of great information. Seth, thanks once again for being on the show. Thank you for watching, and we will see you next week.